This is Susan Holson with the Vermont School Boards Association. Welcome to our lunch break webinar. Today we're going to be talking about the open meeting law. Thanks. So we're joined today by Sue Siglowski, the Executive Director of VSBA, and also Chris Winters, the Deputy Secretary of State, who's going to be sharing the stage with Sue. And of course, you all know Carrie Lamb, who is putting it all together in the background. Carrie, you want to say hi?
Hello, everyone.
Good afternoon, everyone, and thank you so much for joining us for our open meeting law webinar. Today, we're going to be giving you an overview of the open meeting law, talking about executive session, talking about electronic meetings, any temporary changes in the open meeting law during the state of emergency due to COVID-19. We'll also cover email and social media, public comment at board meetings, and the intersection between collective bargaining and the open meeting law. I'd really like to thank Chris Winters, Deputy Secretary of State, for joining us today. And before we get started, Chris, I wondered if you would let our attendees know what the role of the Secretary of State's office is in relation to the open meeting law.
Sure, thanks, Sue, and thank you to the School Board Association for inviting me to participate today. One of the things that we do here at the Secretary of State's office is we answer questions from the public about the open meeting law and the Public Records Act. It's actually written into statute that we provide public agencies and members of the public information and advice around the Public Records Act. It doesn't say anything about the open meeting law in that section, but we provide information on that too. What we generally try to do is to help citizens navigate the Open Meeting and Public Records Act, answer questions, answer emails. We actually have a general counsel whose name is Jenny Prosser, and she's dedicated to municipal assistance and answering these kind of questions from the public. So we get a lot of questions about the Open Meeting Law and the Public Record Act from all the wonderful volunteers who participate on select boards and school boards, or who are citizens who attend those meetings and are interacting with their local government and trying to figure out what the open meeting law says and what it requires of our public agencies and our public boards. So that's just one of the things we do, and so we take the opportunity whenever we can to talk to people about that through webinars like this. Secretary Kondos also does something called the Transparency Tour every 2 years, where he and I go around the state and do about 15 stops talking to different towns and different people about the Open Meeting Law and the Public Records Act and why it's important. So I'm looking forward to the presentation today. Thanks, Sue.
Thank you.
So just to get started here, Sue and I are going to be trading off back and forth throughout the presentation today, taking a couple of slides at a time. And one of the things that we always talk about first when we talk about the open meeting law or the Public Records Act is the declaration of public policy. What's behind it? Why is it important for the public to know what their elected representatives are up to, what their state and local government is up to? And here's the public policy right from the statute, that public commissions, boards, councils, and other public agencies in this state exist to aid in the conduct of the people's business and are accountable to them. So the open meeting law is in statute. It's 5 short sections, 1 VSA 310 through 314. And when you hear someone talk about transparency, this is often what they're referring to. And they refer to accountability of our government through transparency. So being open about what you're doing engenders trust and lets the folks out there know what you're doing on their behalf as a school board member. The open meeting law provides that all meetings of a public body are open to the public at all times, except as provided in section 313. That's the executive session section that Sue will be talking about a little bit later on in the presentation, and I'll be talking about a piece of it as well. The intent of the open meeting law is to create transparency in government. by requiring advance public notice and an opportunity for public participation in governmental decisions. That's a piece of it as well. Not only do you get to know what your public body is up to, what your local school board is doing, but you get a reasonable opportunity to attend and participate. That's why we have notice of these meetings. That's why we have public comment periods at these meetings, so that your school board can interact with the public who want to attend and want to participate, and want to have an opportunity to give you some input. Public body, I guess the next question is, who has to comply with the open meeting law? And it's public bodies of the state and its municipalities. So that includes state and municipal boards, councils and commissions, and any committees or subcommittees of these bodies. That committee and subcommittee piece originally was not in the open meeting law, but it was added. So it's not as though a school board could appoint a working group or a subcommittee and then not comply with the open meeting law. Those subcommittees are also subject to the open meeting law. And when does the open meeting law apply? It's anytime a quorum holds a meeting. What is a quorum? A quorum is a majority of the entire public body. So anytime, if say you have a 5-member board, that's 3 members. A 7-member board, that's 4 members. Anytime a quorum gets together and holds a meeting. What is a meeting? It's a gathering of the quorum for the purpose of discussing business or taking action. So it's not just that they're all in the same room together. When I was a school board member in Berlin, 3 out of the 5 of us were soccer coaches. So there were many times when we were on the sidelines, we might be chatting about whatever, but if our conversation veered into something that the school board had jurisdiction over, that's when we trigger that open meeting law, and we have to catch ourselves. It's happened to me, it's probably happened to you. When a quorum of the public body starts talking about board business, the open meeting law applies, the public has a right to know. So you got to catch yourself and not go down those roads and start discussing board business with a majority of the board present.
In 2018, the legislature amended the open meeting law in Act 166. They added a definition and also clarified what activities do not constitute a meeting under the open meeting law. The definition that was added has to do with business of the public body, and that definition is business of the public body means the public body's governmental functions, including any matter over which the public body has supervision, control, jurisdiction, or advisory power. Act 166 added the bold language that you can see at the bottom of the slide to clarify what is not a meeting. So a meeting is not any communication, including in person or through email, telephone, or teleconferencing between members of a public body for the purpose of scheduling a meeting, organizing an agenda, or distributing materials to discuss at a meeting. But here's the important part, provided that no other business of the public body is discussed or conducted. Act 166 also clarified that meeting shall not mean occasions when a quorum of the public body attends social gatherings, conventions, conferences, training programs, press conferences, media events, or otherwise gathered. But here's that same language again in bold, provided that the public body does not discuss specific business of the public body that at the time of the exchange, the participating members expect to be business of the public body at a later time. So this clarifies that a quorum of your school board could attend a conference and not be considered to be having a meeting, provided that you're not discussing specific business of your board. Act 166 also clarified that meeting shall not mean a gathering of a quorum of a public body at a duly warned meeting of another public body, provided that the attending public body does not take action on its business. So there may be a time when your school board would need to attend a meeting of the select board, and that would be fine, provided that your school board is not taking action at that select board meeting on school board business.
So going back a little bit to what I was saying earlier about that meeting on the soccer field, a meeting can occur in any physical location. It doesn't mean that you're located at your appointed date and time at the supervisory union office or something like that. It can occur anywhere. It includes work sessions and retreats. There's no such thing as a work session or a retreat that's not an open meeting. Although the law recently did, Sue was just referring to parts of the law that modified that. It did allow for some of that to happen. But if you're discussing board business, and it's not just training issues, then it is a meeting and falls under the open meeting law. A meeting doesn't have to occur all in one space. It can occur over a span of time. It could include an email string, an online conversation, where maybe it starts with just one or two board members, but then when that discussion expands beyond a quorum of the board members, you've triggered the open meeting law. You're having conversations, you're having discussions, you're making decisions without the public being there and violating the public's right to know. There are a few exceptions to this that we can get into here. It's that group emails can be used to schedule a meeting, to create an agenda, or to distribute materials to discuss at a meeting. So you might want to distribute an agenda, you might want to figure out what's going to be on that agenda, but discussing the topics themselves should never happen outside of a duly warned open meeting where the public has a right to attend. That public notice is required, again, so that the public has a reasonable opportunity to be there, to give input, to participate in some fashion. Also not without limitations, I should say, and we'll get into that a little bit later. But regular meetings are those meetings that you typically would set once a year, perhaps after the new election, perhaps in January at the beginning of the year, to set the regular time and place of meetings. For example, every third Monday at 7 p.m. at your local school. That's a regular meeting. That's something you can set up in advance, and that's what the public should expect, unless there's a special meeting. And I should say regular meetings are the agenda has to be available and they have to be posted and warned 48 hours before each meeting. Special meetings, those that are outside of those regular meetings that we just mentioned, you can do those on 24 hours notice. And you also can give notice or are required to give notice to newspaper and radio stations serving the area, to any person who specifically asked for it in writing, and to all members of the public body for a special meeting. Again, post and make the agenda available 24 hours in advance, and that includes posting to any website that the public body maintains. Emergency meetings should really be used sparingly. We get a lot of questions about this. When someone asks us about an emergency meeting, it's often not really an emergency meeting and it's definitely not if you can give 24 hours notice. When we talk about emergency meetings, we often give the example of the road foreman and the select board and someone from A&R, meeting on the side of the road with a select board after Irene, trying to figure out how to put the roads back together. There's an example. There were hundreds of emergency meetings happening all over the state post Irene without really you needed to do it right away, and you didn't have time to warn those meetings and give the public an opportunity. But just because you forgot something on the regular meeting agenda, or you've got to have something signed within the next 3 days, that's not an emergency. That's something that you can warn through a special meeting. Next slide, please. And I'm forgetting how far I'm going here, Sue. Agendas.
You have this one.
I have this one and the next one. Okay. And the one after that. All right. So agendas, the time to post agendas, at least 48 hours before regular meetings, 24 hours before special meetings. And where do you post them? It's on a website that the public body maintains or designates, in the clerk's office, and in 2 designated public places. There is a bill, I should just mention quickly here, that's pending. I think it's passed the Senate and maybe headed toward the House, to allow for posting in 2 electronic places in lieu of this requirement during the declared state of emergency. So there have been some provisions that have changed. That has not passed yet. So for now, it's the website, the clerk's office, and in 2 designated public places. With respect to providing an agenda, you have to make it available to people on specific request prior to the meeting. So if someone's looking for an agenda, you do that. Sometimes there's a standing request from the media, perhaps a journalist, or someone who's just really interested in what your board is up to. They can have a standing request that will last for the year, wanting to get the agendas of the meeting ahead of time. The content of your agenda, it should be specific enough so that the public, if someone knows what's going to be discussed and possibly wants to have an opportunity to attend and participate, specific enough that they know, what is going to be discussed and what the potential action items are on that agenda. So to let the public know if the board is actually going to take action on something or just discuss it. Any addition or deletion to that should be the first act of business at the meeting, and other adjustments can be made at the meeting. Something that we advise as a best practice is if something was forgotten, something comes up last minute, you can put it on the agenda for a discussion item, but any action, we really advise that you put that on the next agenda if you can, or you warn a special meeting so that the public knows you're taking action and it doesn't appear that you've popped something onto the agenda last minute and taken action on something that maybe someone would have liked to have been there for or listened to. And with respect to minutes, the laws doesn't say very much about minutes. Actually, it's fairly a bare bones requirement, but it's really up to you as a public body to determine how detailed you want your minutes to be. They do, at a minimum, have to cover all of the topics and the motions that arise. They have to cover who is present, any active participants, any motions or proposals, resolutions and their dispositions, and vote results, noting individual votes if there is a roll call on the action item. They have to be available for inspection and copying upon request, no later than 5 calendar days after the meeting. So hopefully within 5 calendar days, you've got at least a draft of the minutes ready to go. They do not have to be final approved minutes when the public requests them. You can provide them and just make sure that you note that they are draft minutes, and they can become final approved minutes at a later date when the board has a chance to look at them. They need to be posted on a website that the public body maintains no later than those 5 days. And if there were a few special provisions passed for open meetings due to COVID-19 and the state of emergency that we're under. So one of those changes was that school board may extend the time limit for posting of minutes to up to 10 days from the date of the meeting, just figuring that there might be staff shortages and more difficulties in complying with the open meeting law during the declared state of emergency. Those minutes do have to remain posted to a website for at least 1 year, with the exception of draft minutes. They can be replaced by the final minutes. And we try to remind people that those minutes are the history of your board. Those are records that should be kept permanently and archived, whether it's on your website or whether it's stored somewhere else. Those minutes are the history of your board, and I can say from personal experience, there are times when you'll be glad you had them, and you can go back and see what that decision was, what that rationale was behind taking an action as a board from 5, 10, even 15 years ago.
Before we move on to executive session, I wanted to see if there are any questions. Carrie, I do have one question that was emailed that I was going to bring up, but are there others?
There are more, and while you're answering these ones, we can invite people to type in any questions that they have about what has just happened.
Okay.
And I will read off these questions after you finish yours.
Okay, so the one that I have that was emailed says, if the board is viewing documents during the meeting, I should start by saying this person says, this came up at our virtual school board meeting last night. I have a question pertaining to open meeting law, especially now that we're having meetings electronically / online. If the board is viewing documents during the meeting, do all those documents fall under open meeting law and should be made available to all in attendance at the meeting? Or does the open meeting law pertain to the discussions and/or decisions / motions which are made during the open meeting? Do you want to try that one, Chris?
Sure. Here's what our advice would be, that documents discussed in the course of an open meeting would likely be public records. So maybe not specifically addressed by the open meeting law, but the Public Records Act. Best practice is going to be to share those documents unless perhaps that they are attorney work product, working drafts, subject to the board's approval. But for the most part, typically those documents should be shared with anyone attending the meeting so that they can understand what you're talking about, subject to the right to know under the Public Records Act. I don't know if you feel the same way about that, Sue.
Yes, I do. Thanks.
Okay, the next question. How about a Google Doc for sharing teacher appreciation planning? Is this a meeting?
Great question. We do get that one quite a bit. Collective editing of a document can be really tricky. And I'll say that we tend to give really conservative advice about this. On any of these opinions that we give out to people who ask questions, we do at the end of it always say, check with your own legal counsel, follow the advice of your board's attorney if you've got one available. Sometimes we say give a call to the School Boards Association or the League of Cities and Towns for further advice. But we err on the side of caution and say that collective editing of a Google document can turn into one of those electronic meetings, especially if you're discussing the business of the board, especially if you're doing something important like policy. Not saying teacher appreciation is not important, but it's probably not a policy decision. But what we do recommend is that when you're editing collectively, you have one point person and you send all of your edits back to that one person. So it's only 2 school board members at any time interacting on the document. Now that probably seems like an overabundance of caution, but that's what we recommend. There are times when you could be collectively editing a Google document and you actually get into a discussion on important policy matters that, if you're a member of the public, you might like to know that was happening behind the scenes and not in an open meeting.
Thanks,
Okay.
Chris. That aligns with the advice that we provide as well.
Oh, that's good.
Great, it's always good, right? And the next question is about, I believe it was typed in when you were talking about the places to post the warnings. It says, is one of the 3 options, because I believe you gave 3 options of places to post warnings, is one of the 3 options enough for a public body?
I'm not sure I understand the question. Are they saying, can you use only one of the 3 options?
That's what it sounds like.
Sue, do you want to try that? I'm trying to pull up the actual piece in the open meeting law about that.
Okay. I'm going to look back at the slides here. Time to post. Where to post? Okay. Requires posting on a website that the public body maintains, in the municipal clerk's office, and in 2 designated public places. So I'm not sure if the question is asking whether you can just do one of those 3 things or whether you can only, if you could, okay, no, you need to do all of those 3 things.
That's right.
Yeah.
Okay. All right, the next question. Can action be taken on an issue not warned on the agenda but added to the agenda at the meeting?
I think you heard me very quickly give our recommendation which is that if you always go back to the public's right to know and to have a reasonable opportunity to participate, if you add an action item the night of the meeting and take action on it, you may have eliminated that public member's chance to be there and to hear what's going on and to maybe comment or maybe have some form of input on that. So our recommended best practice, and there's a lot of gray area in the open meeting law, but our recommended best practice would be to put that on a future agenda, or if it's urgent, then even schedule a special meeting for the next day or two, and have that fully warned, allow the public to know what you're planning to take action on, and then take action on it at a future meeting that has been properly warned. And unfortunately, we also get the horror stories at our office. For the most part, board members are great people trying to do the right thing and don't have this kind of a bad intent when doing these things. But we have seen the cases where a board will show up, probably a select board, never a school board. A board will show up and say, oh, that, person who's always against what we're trying to do in this area is not here tonight. Let's add that agenda item now when they're not here and vote on it. And unfortunately, that has happened. It does happen. So again, our recommended best practice is you can have the discussion, but put the action item on a future agenda, warn it properly, allow the public to attend, and then vote it then.
Thank you. Sue, do you have a comment on that?
No, I think Chris has covered it. Are there any
Great.
other questions?
There are a lot of them.
Oh, wow.
The next one,
Okay. Go ahead.
how much of the discussions in the meeting have to be in the minutes? And I believe you talked about that already, but it'd be good to clarify.
Yeah, our advice is as much as you want, but the statute requires bare bones. Maybe don't do that to your staff assistant and ask them your minute taker to do verbatim what you're talking about. But the law really just requires you to note the motions, proposals, resolutions, and their dispositions, and then just take a look at it with an eye toward this is the history of our board. So what substantive pieces of that discussion are important to understanding the motion and the decision?
Okay, so the next question is, how would you share with members attending virtually? And I believe what she's talking about is, how would you share the documents for the meetings, the handouts for the meetings with people attending virtually? I know in Barry that when they send out the agenda, they send out the handouts along with the agenda. So I don't know if that's helpful.
I
Yeah,
think most boards send, sure. So I think most school boards, when they send the agenda, there is a packet attached and has the documents that they'll be reviewing and looking at their meeting. If there's a document that is not included in the packet, there certainly is through use of the remote meeting platform, there is a way to share documents on the presenter's screen, much similar to the way I'm sharing my screen with you right now. So that's always an option as well, and that may be a good practice to use in any event, because there will be people who are watching the remote meeting who may have not have received the packet. I don't know if you have anything else to add to that, Chris.
Yeah, it's a tricky one. We're all learning. We're all trying to figure out this new way of doing meetings. Some people won't be able to be on something like a GoToWebinar or a Zoom call and may just be dialing in by phone. So that presents a real challenge. Hopefully, as Carrie said, you can get things out to people in advance as a package, as part of the agenda packet, and so you don't have to discuss anything that someone wouldn't already have in front of them.
Okay, next question. Open meeting law still applies to committees if the full committee is less than the quorum or the full board. Is that correct? The statement that must be a full quorum of the board seemed to suggest otherwise. Looking for clarification. So it sounds like she's saying open meeting law applies to committees of the board, regardless of if there's a quorum of the board there or not. Is that correct?
That's correct.
I'm glad you could answer the question, Chris, because my audio just faded out for almost the entire question.
Yeah. When it comes to committees, the open meeting law is triggered with a quorum of the committee, not a quorum of the full board. The open meeting law does fully apply to committees. And again, I'll go back to some of our terrible examples that we hear about here at the Secretary of State's office, where boards might try to hide some of their work, and it doesn't happen that often, but it has happened. And I think that's why the law was rewritten or amended to include committees, to be clear that the open meeting law applies to committees, because some boards were assigning very important work and policy decisions to subcommittees and then saying, oh, open meeting law doesn't apply, we'll have them go do all of this work behind closed doors wherever they want to do it without the public's right to know being honored. So I think that's why the legislature chose to say very clearly that subcommittees are subject to the open meeting law and that it's a quorum of the committee, not just a quorum of the full board.
Okay, this is a kind of a question that's a follow-up from a previous one. What if action was taken on an issue not originally warned on the agenda? What is the next step? Should they warn it at the next meeting?
Yeah, I think we often advise, and I don't know if Sue, if you approach this the same way, to take some corrective action just to be sure, because a violation of the open meeting law, part of the enforcement provision is that perhaps a court would find that action is not enforceable because the open meeting law was not complied with. So when in doubt, of course, check with your own legal counsel, but when in doubt, you can reaffirm the decision at a future meeting, properly warned, take the proper motion, take the proper vote, just to be to err on the safe side. And Sue, feel free to contradict me, because as I keep saying, there's a lot of gray area in this law, and we try to advise people as best we can. Always tell them to check with their own attorney, and our advice is really geared toward the side of transparency and being very careful about erring on the side of caution and transparency and the public's right to know.
Our advice always errs on that side as well, Chris. And the only thing I would add is that in a lot of these questions that come up, it's really important to know the exact facts of the situation, and that's one of the reasons why we often will refer boards to their attorney for specific legal advice.
Okay, this is an interesting question. I think it's similar to the Google Docs, but I'm not sure. Meeting open records regimen for asynchronous discussion, Slack channels, for example. Do you all know what Slack channels are?
I haven't used it.
I haven't used it. I've recently been invited to a Slack channel, but I don't know anything about it.
I think so an asynchronous discussion thing. So this is one of those conversations that happens over time. It's not happening in real time.
It sounds like a Google Doc type situation.
Yeah, I guess going back to the previous advice, it doesn't have to happen in real time. An email chain, a text chain, a Facebook conversation. When it eventually, it might not start out that way, but when it eventually evolves a quorum of the board, a quorum of the public body, and they are discussing business or taking action even on business, making decisions that are within the jurisdiction of that public body, our opinion is that you're running afoul of the open meeting law at at that point, because not everybody's on that text, not everybody's on that Facebook discussion. You're doing business with the board without the public being there.
Yes, and he just wrote in it's more like a Facebook conversation. So you're saying that it's the same thing. Okay.
And that's a really a tough one, I'll just say, because we all, and myself as a former school board member, public officials, they want to be accessible to their constituents, to the people they're serving. And so Facebook is a great way to do that, can be a great thing, not always a great thing. But you can get a lot of input, a lot of feedback that way, but I think you just have to be really careful about engaging in actual discussion among board members in those forums.
Okay. On to the next one. Looks like he has a correction in the middle, so let me just take a second here. Okay, posting of agendas. If you're part of a unified union where there are multiple towns involved, does the posting of 2 public places pertain to each town, or is 2 public places per town?
Do you know the answer to this one, Sue? I'm not positive.
Just taking a look again. I believe I think it's 2 designated public locations. I don't think it's 2 locations in each town.
We can clarify that just to be sure and send it along with the post webinar email.
Yes.
Good.
All right. Is a negotiation team a board subcommittee?
Yes.
Well, that was a quick answer. All right. So they have to take minutes of their subcommittee and the negotiations committee.
I'll get into that a little bit later in the presentation. That's the last part of the presentation.
Okay. If minutes refer to a document that isn't generally publicly available, for example, a plan that was first presented at this meeting and was then approved, must the documents be filed or electronically available in the same place as the minutes? Let me read that to you again.
Yeah.
If minutes refer to a document that isn't generally publicly available, for example, so if the minutes refer to a handout, must the document be filed electronically along with the minutes?
I don't think so. I don't think the law requires anything other than the posting of minutes. So you wouldn't have to do that. That is a public record and could be requested and would have to be made available at that point. And then some boards decide, some towns decide, if we're going to get a lot of requests for something, we might as well just put it out there. So there's nothing stopping you from posting it publicly, but the law does not require it to be attached or posted with the minutes.
Okay. Can committees and subcommittees take action at all, or is all of the action taken on the board level?
That's an interesting question. I think, and Sue may have some other advice on this. I think that the subcommittee can take action that the board empowers them to do in the creation of the committee, but the typical committee or subcommittee action is to bring things back to the full board for a decision.
Yes, I would agree with that. When the board forms a committee, normally the committee has a charge, and the committee would be holding meetings regarding that charge, but they would be bringing recommendations back to the full board. So the committee could make a decision that they're going to recommend something to the board rather than making a board level decision.
Okay, and the next question, I believe I know Sue has an answer for. Are there parameters for the lengths of public comment periods? I think that's in policy, right?
Yes. We have a model. VSBA has a model policy regarding public comment, and the we're going to get into public comment a little bit later in this presentation, but the law does allow the chair of a board to make reasonable rules around public comment, and those would need to be evenly applied.
Okay, so the next question I think I can expand upon a little bit to understand what he's saying. He said, what if the minutes say the board approved a plan, but don't say what the plan is? And I think that's similar to, I think boards have left executive session and said, we approve what the superintendent suggested in executive session, that type of thing. I think he's saying, do the minutes need to say what was approved?
I think that's definitely best practice to actually come out and say what was approved and not just refer to something that's not included in the minutes.
I would agree.
That was the last question for now.
All right. We're going to have to speed it up a little bit on the second half of our slides.
Right. I have one more question, actually, that I wondered if you had any thoughts on, Chris. In the statute, for what is not a meeting, it includes the word trainings. And I'm wondering about your thoughts of when a board has a training, say from their attorney, and they all get together just simply for that purpose, whether you think that would be considered a meeting.
Yeah, I think that falls under that exemption, Sue, that we were talking about. I do remember being in on some of the legislative discussions when they were talking about these exemptions, and they were talking about education of board members. So if you're just talking, if you're training them on the open meeting law, we want to encourage that. Public doesn't necessarily have to be there for that, although they could be invited, they could attend. But that falls outside the definition of a meeting, I think, under the exemption.
Okay, thank you. So next we're moving on to executive session, and this is definitely a meaty topic and one that's very important for board members and especially board chairs to understand. So first we'll talk about when it is appropriate. It's really only appropriate if the business to be considered fits into one of the 14 statutory categories, and only if the public body votes to enter open session, enter executive session in open session, and indicates its reasons for doing so. The motion to go into executive session must state the nature of the business of the executive session. It must be supported by a majority of the board and be recorded in the minutes. And we encourage boards and board chairs and superintendents when they're preparing their agenda that if there is a question about whether it would be appropriate or not to go into executive session, it's helpful if you can consult with legal counsel about that ahead of time. It can really help you avoid some sticky issues if you plan ahead. There are some topics under the executive session law that require a specific finding that, and this is the bold language, premature general public knowledge would clearly place the public body or person involved at a substantial disadvantage. And listed below the bold language, you can see those specific topics that require that specific finding. They include contracts, labor relations agreements with employees, arbitration or mediation, grievances, pending or probable civil litigation, if the public body is a party, and confidential attorney-client communications. So under premature public knowledge, we have the example of a board intends to discuss a contract with a bus company. Does the board automatically vote to enter executive session? In this example, it's not an automatic that you're going to go into executive session just because you're talking about a contract. First, the board has to determine that discussing the contract in open meeting would result in premature general public knowledge that would clearly place the board or perhaps the bus company at a substantial disadvantage. There is a Vermont Supreme Court case on this topic, and the general takeaway from that case, which is called Trombley versus Bellows Falls Union High School, it's from 1993, is that it is not unworkable for a public body to make a careful analysis of need before deciding to go into executive session. We recommend that the board actually use 2 motions for these topics that require a specific finding of premature general public knowledge would clearly place the public body or person involved at a substantial disadvantage. So for the bus company example, the first motion would be, I move to find that premature general public knowledge regarding the board's contract with Best Bus Company would clearly place the board at a substantial disadvantage because the board risks disclosing its negotiation strategy if it discusses the proposed contract terms in public. And that motion, of course, would require a second, and the board would need to vote on that motion, and that motion would need to be approved before you would move on to the second motion, which would be, I move to enter executive session for the purpose of discussing the board's contract with Best Bus Company. And then you could add in which provision of the executive session law you're referring to, just to be very specific. Another example would be a leave request. So the first motion would be something along the lines of, I move to find that premature general public knowledge regarding an employee's leave request would place the employee and the board at a substantial disadvantage because it would reveal personal medical information of the employee. That would be voted on, seconded and discussed, voted on, and then a second motion would be required to actually move to enter executive session for discussing that employee's leave request. Oops.
So here are a few other permissible reasons to go into an executive session, and they're very specifically laid out in 1 VSA section 313A 2 through 10. They are the negotiating or securing of real estate purchase or real estate options, or lease options, I should say. Appointment, employment, evaluation, discipline, or dismissal of a public officer or employee. Student academic records, suspension or discipline, exempt public records under the Public Records Act, clear and imminent peril to public safety, security or emergency response measures if disclosure would jeopardize public safety. Next slide, please. So these are reasons for, whoops, could you back up one, Sue? So these are reasons, that's okay. These are reasons for executive session where only one motion is recommended. You don't have to go through that other process of finding that premature general public knowledge would place the public body at a substantial disadvantage. These are one motion executive session motions. It should identify the topic of the discussion and the specific statutory provision. So it's not okay to just say going in to discuss legal issues or legal advice or a personnel matter or a student matter. They should be more specific and say something like, I move to enter executive session for the purpose of discussing the evaluation of the superintendent under the provisions of Title I, Section 313A3, which is the one about evaluation of a public officer or employee. That topic, as I said, does not require a specific finding of premature general public knowledge, placing the public body or person involved at a substantial disadvantage. And again, here's another piece of recommended language for the motion. I move to enter executive session for the purpose of discussing the suspension of a student under the provisions of Title I, Section 313A7, of the Vermont statutes. So again, you're trying to give the public, those in attendance in particular, at least some idea of what you're going into executive session to discuss. And just imagine how that makes the members of the public feel when you say, oh, we're going into executive session to discuss a personnel matter or a student issue or to get some legal advice. Be as specific as you can, and understanding that sometimes that's really difficult to accomplish.
So what happens once you are in executive session? It's important that when you're in executive session, the board can only discuss the subject matter that was referenced in the motions that we were just talking about, that were the motions to enter the executive session. The board can decide who will attend their executive session. They may want to invite in legal counsel, staff, or anyone who is the subject of discussion or whose information may be needed by the board. And minutes are not required to be taken during executive session, and we do not recommend that they be taken. It's important to remember that a board cannot take any action in executive session except for actions related to securing real estate options. So your ultimate action on all other items must be taken by motion and vote in open session. And that motion, refers back to a question that was just asked. That motion should provide enough information, subject to the confidentiality considerations, to allow members of the public to understand the nature and the substance of the action that was taken. Unless some other law requires it, a public body may opt to conduct its business in public, even if an executive session is permissible.
And so now a little bit about meeting by electronic means. The open meeting law does allow for electronic meetings with some restrictions. A member participating remotely has to identify him or herself when the meeting convenes and be able to hear and be heard throughout the meeting. If a quorum or more of the public body is participating remotely, the agenda has to designate a physical location where the public can attend and participate, and one member must be physically present. I think that could also be a staff member can actually attend at the physical location. And the physical location requirement, there have been some changes with respect to COVID-19, and we spent a lot of time early on with the House and Senate Government Operations Committees trying to put some emergency provisions in place to allow school board and select board and other public body work to continue without that physical presence, without members of the public being physically present. So there are some physical location requirement changes under COVID-19. There is no physical location requirement. The meeting can be held completely electronically, subject to some specific restrictions in that emergency law. Under the existing law and the emergency law, any vote not unanimous must be taken by roll call. So if there's a voice vote on something and the public listening in can't tell who voted how, there has to actually be a roll call. In the state of emergency law, because of COVID-19, the physical location requirement has been waived as long as there's a state of emergency, and it'll go back to the regular law once the state of emergency is lifted. The board has to use technology that permits the attendance of the public through electronic or other means. And whenever feasible, the board must allow the public to access the meeting by telephone. And this was a recognition that not everyone knows how to use a Zoom or a GoToMeeting or would have access to a computer or internet to do that. So whenever feasible, the board should use a landline telephone option as well. Boards have to post information about how the public may access the meeting electronically and include that information in the published agenda, such as how to access the Zoom meeting or whatever technology, Skype or whatever the board may be using to meet electronically. There is a requirement that school boards record those meetings unless there are some unusual circumstances that make it impossible to do that. The intent behind this was because we're doing something really different, because the public has less access, potentially less access to these meetings, potentially doesn't pick up on everything when they're on a phone call, that the meetings be recorded so that there is a record of what happened at those meetings, that any member of the public could go back and view, or that we could see if the minutes don't capture what exactly happened in these temporary emergency, temporary provisions under the existing state of emergency. Boards can use electronic communications to schedule a meeting, to organize an agenda, or distribute materials. That was one of those provisions that we talked about early on. This does not constitute a meeting, just to have an email discussion about scheduling, organizing, or distributing materials. But the following are probably not permissible. And as always, we say consult your own legal counsel about this. But as we discussed, group emails that discuss the body's business would trigger the open meeting law, and is not something that any board should engage in. Collective editing, again, you all hit these through your questions earlier, but collective editing of a document by a quorum is very dangerous business, and we recommend against that. Participation in a Facebook group or a front porch forum by a quorum if the body's business is discussed. It's okay to be a part of that, but I think when you start discussing the body's business and a quorum of the board has chimed in at some point, you're at that point engaging in something that could be considered an open meeting. So the public comment period that every board should have when they have a meeting. We just remind people that board meetings are public meetings, but they're not a meeting of the public. There are restrictions to what the public can do at these meetings. We recognize board members have to get their business done. They have a charge. They have things that they need to do. They do need to listen to the public. They do need to give the public an opportunity to participate, but it can be subject to reasonable restrictions. And those public comments can be subject to reasonable rules established by the chair. We get a lot of calls where those things, where that friction happens between a member of the public who really wants to have their say and perhaps a board chair who thinks they've said enough, or it's not an efficient way to conduct a meeting. It takes too much time. So the board chair can set reasonable rules about the public comment period, but just respecting the fact that the public has a reasonable opportunity to appear and express their views on any matter considered by the board.
Before I move into penalty and enforcement, Carrie, are there any questions?
Oh, yes. Are you ready?
I thought there might be.
If the board recommends approval of the leave for an employee, when the board goes back into public session, does the motion to approve the leave have to include the name of the employee, or should it be quote unquote approve the leave of an employee as discussed in executive session?
What do you think on that one, Sue?
I think my thought is that it is okay not to name the employee because one of the reasons you went into executive session is to protect any confidential information that involves that employee. So that's my thought. What do you think, Chris?
Yeah, it's a really tricky one. You're always trying to balance the privacy issue with the public's right to know. I think it really depends on the circumstances, on the specific facts. So we try not to wade into those areas if we can help it, and would encourage the board to rely on their legal counsel to look at whether there's a real solid exemption there for why that had to be an executive session, and why it probably wouldn't be a good thing to reveal that individual's name after coming out of executive session.
Okay. To go into executive session for two separate matters, can both be made in one motion, or are two executive session motions required?
I think you could do them. You could do them both.
Okay. And if there's a problem with one of them, then someone can single that out as part of the discussion.
Mm-hmm.
How aggressive can one be with using waiting rooms, meeting passwords that must be requested versus posting openly online and ejecting Zoom bombers?
Yeah, great question. This is one that I know a lot of boards are struggling with, and so members of the public are struggling too. You know, it's part of that the reasonable rules of the chair, I think, of trying not to allow people to disrupt meetings. Hopefully people are getting better with the technology so that they can mute participants or eject participants who are not following those reasonable rules of the chair. But again, it's a fine line and people are learning as we go, but to require a password or require specific instructions, difficult permissions, you're making it harder for the average member of the public to attend. But at the same time, you've got to protect your board's ability to get its work done and prevent against Zoom bombers. We're seeing this play out in the legislature too. When they're holding meetings, you have to get a specific invitation and password and be allowed in before you can testify. And that, you know, to some extent is making it harder for the public to comment on what the legislature is doing. Because normally in a legislative session, there'd be people sitting around the outskirts of the room who could just raise their hands and ask a question. So hopefully your technology allows that to happen and allows you to control people disrupting the meeting. I kind of did not give a very clear answer on that, but I don't think the law is very clear on this yet, and we're all still trying to figure out the best way to make that happen. Again, balancing the public's right to know, the public's ability to attend a meeting with the kind of disruption that can happen if you have a wide open meeting.
Okay. Can a participant enter executive session without being noted in the minutes? For example, I know at most meetings I go to, when they go into executive session, they'll say the board has invited the principal and the curriculum coordinator to come into the meeting with us. And I think this person wants to know if that needs to be in the minutes, who was invited into executive session.
Do you know if that's in the executive session law, Sue? I'm just going to take a quick look here. Our advice is it's definitely best practice to note who went into executive session, but I'm just not sure that the law around minutes or executive sessions require it.
Yeah, I don't remember seeing it in the law, but we would agree that it is best practice to note that in the minutes. But you may find that it's actually in the executive session statute, Chris. Let us know if you do.
Yeah, I will. I'm looking at it right now.
Okay.
I don't see that it's required to be put in the minutes in the executive session statute. It does say it shall be limited to members of the public body, and at the discretion of the public body, you can bring people in. But it doesn't say anything about recording that in the minutes, although we would advise that, as you do, as a best practice to let folks know who was in that executive session.
Okay. Can the video recordings be posted on a YouTube page to be shared with the public?
Sure.
All right. When holding an electronic telephone meeting, is the public required to have access to the meeting electronically, or if they have access via phone, does that satisfy the open meeting law?
Phone is the minimum required. Not required. It's highly recommended. A phone line should be available if feasible. So phone is definitely adequate under the law.
And someone says, beginning on the 5th, I think Zoom requires a password. So must a board share it with everyone who requests it?
I think so. I don't know about you, Sue, but I think so. But there's still that debate about whether you post that password publicly. because of the disruptors who might sign into the meeting and try to make trouble while they're an anonymous participant.
Right, or that you could post who they could call to get the password. Is that what you're saying?
Yes, I think so. I think that's probably the best practice. Yeah.
Okay, that's it for questions.
Okay, thank you, Carrie. We'll move into the last part of the presentation involving penalty and enforcement. There is an enforcement provision in the open meeting law, and anyone who is aggrieved must allege a specific violation of the open meeting law and make a request for specific actions to cure the violation. They would make that request to the public body. And then the public body has 10 calendar days to respond. If they acknowledge a violation, they have 14 calendar days to cure it and take measures to prevent reoccurrence. Failure to correct a violation could result in attorney's fees and other litigation costs. So this is why it's so important. In addition to transparency, you could be putting your district at risk for attorney's fees and other litigation costs if you don't comply with the open meeting law. Lastly, we'll just touch briefly on open meeting law and collective bargaining. In 2018, the Vermont Supreme Court issued a decision in the Caledonia Central case, holding that the open meeting law does not apply to collective bargaining negotiations between an SU negotiating committee and a teachers union because such negotiations are not meetings under the open meeting law. And in its decision, the court stated that the open meeting law was ambiguous and it relied on the interplay between the open meeting law, the Vermont Labor Relations for Teachers and Administrators Act, and the Public Records Act to resolve that ambiguity. So what does the court's decision mean? Since the open meeting law does not apply, negotiations themselves are not required to be held in public. It does raise questions, however, about whether an SU negotiations council is required to warn its negotiation sessions. And that is because during those sessions, there may be periods of time when that committee is meeting by itself to discuss priorities, strategies, etc. And depending on the facts and the circumstances, such a gathering might meet the definition of a special meeting under open meeting law requiring posting of a notice at least 24 hours prior to the meeting. Because this is an extremely complex area and there are many issues raised by the Supreme Court decision, the VSBA advises districts to work with their legal counsel when they're planning negotiation sessions to ensure compliance with the law. And lastly, I'd just like to note that negotiations can be held in public if both parties agree to it. We've come to the end of our presentation. I'd like to invite everyone to contact myself or Chris whenever you have open meeting law questions. We're happy to talk with you, and sometimes we can provide answers. There are other times when we will probably say that we advise you to consult with legal counsel. Is there anything you would like to say in closing, Chris?
I do have two more questions if you'd like to take them.
Oh, okay. Go ahead.
It's relevant to the piece you just were talking about. One is, does a Q&A like this webinar format comply with open meeting law as long as a phone line is available as well? Because we did have a phone line available for this.
I guess I'm not sure what the question is I guess if there was a quorum of board members on this call?
Yeah, I believe they're saying, is this format okay for a board meeting? And
Oh, this format. Yeah, I would think so.
All right. And the last question is, does violation have to be alleged in writing? Violation of the open meeting law.
I would say yes, because there are time frames that are triggered. So it would need to be clear when that complaint was made.
Yeah, I'd
Okay.
agree with that, Sue. It's good to have in writing as well, so you're clear on what the violation is that's being alleged, and that, doesn't change at some point.
Great. Thank you very much. That's it.
Yeah, I guess in closing, I'd just say thanks for the opportunity, and want to thank all the school board members and superintendents and other people on the line who serve our Vermont children so well. And please do get in touch with us, with Sue, with me. I'll give you one more email. So this is one that only the folks listening to this webinar will have. That's for Jenny Prosser. She's our municipal assistance attorney, and she answers similar questions all day long. She's really great about getting back to people. I'm not always as easy to reach, although email is the best for me. But Jenny, Jenny .Prosser, PROSSER, at vermont.gov. If you hit me or Jenny, one of us should be able to get back to you fairly quickly. Thanks again.
Thank you, Chris. And I would also like to note that Chris is a former school board member. So thank you for your school board service as well. And thank you to all of our school board members who are listening, and superintendents, business managers. We really appreciate all of your hard work during this very challenging time, and wish you all the best and good health.